Can an employer use your photo on the company website? How do non-competes work? And what should I do if I think I got COVID-19 at my workplace? These are just several of the questions you may have about the workplace and COVID-19 and this whole new life that we all have. So we wanted to make sure that you get the answers that you're looking for. Nicole Patino from the law offices of Nicole Patino, Gabe Snyder from Ward Black Law are here to answer your questions about workplace issues and workman's comp. You can get to those experts by texting them. So what you do is you text your question. The number is right now on your screen, 336-379-5775. Remember, this is text only, so please do not call. All right, first and foremost, Nicole, let's start with this whole thing. Lots of companies, take pictures of their employees. They use them on the website, on pamphlets, that kind of stuff. Is that allowed, and what happens when you leave?
So they probably can do it. Usually the company's going to ask for permission. What I've been seeing recently, though, is a lot of companies are using the employee's image and leaving it up on the company Facebook. So one thing that I can do is help remove your image from these company websites if you're no longer practicing there. Comes up a lot with doctors or dentists who have left a practice but are still listed as one of the exemplary doctors there.
Oh, I see. Okay. And they've just got your face up or something like that in a post that could have been a year old or 3 months old or whatever.
Or in their photo gallery.
Or in their photo gallery. Got it. Okay. Good to know. All right. Gabe, let's talk about this. What happens if you get COVID at work? Is that a workman's comp claim?
That's a great question. So in North Carolina, it depends on what you do. So in North Carolina, you have to have an occupation, obviously, and that occupation has to put you more at risk than the general public to contract COVID. So for instance, an example may be a stewardess on a plane or a nurse who's in the COVID unit, and they're more exposed to COVID than other professions. And so we would say that they would be entitled to workers' compensation if they go out as a result of COVID.
Okay, and maybe any lost wages or any health care monies that you would have to spend for your care?
That's right. So while they're out of work, in other words, disabled because of COVID, unable to work, then they would be entitled to their average weekly wage every week. Also, any medical expenses related to the COVID injury. So any hospital stays, doctor visits, everything like that, the employer will be responsible for that so long as you can prove that it was COVID you got at work and that your profession is one that puts you more at risk than the general public to contract COVID.
Gotcha. Okay. All right, Nicole, let's talk about non-competes. Not every, job has a non-compete, but they're becoming more and more common. So what should we know about these? And is it something that when you're signing it, you know that that's what it is, or is it buried in a contract somewhere?
It could be both. Non-competes are kind of a hot topic right now. So one thing that employees should be aware of right now, we're experiencing this great resignation wave. That's what people are talking about. And part of what employees may not understand is that even when you leave a job, these non-compete obligations may remain in existence for some time. Confidentiality requirements can remain in place indefinitely. And there may be non-solicitation provisions, so you can't tell your best work friend to come work at your new job. These things are really important to know about before you leave an employer.
Okay, and so a non-compete should be something that you had actually signed, so you should have that document.
That's correct. And if you don't have it, call HR and ask for it. You want to make sure that you review that and that you understand what is in that document, because it may play a huge decision or a huge role in your decision to leave the company or not.
Because you may not be able to leave and do the work that you're supposed to do at that other company if you have that non-compete. Okay.
Exactly.
All right. So Gabe, let's talk about how do people know if they have a workers' comp claim?
That's a great question. So workers' comp basics is that you have to have an accident while in the course and scope of employment. So a classic example is like a slip and fall for a nurse. You're walking down the hallway, you're attending to a patient, you slip and fall. There's an accident while you're doing your job. And so anytime there's an accident while you're doing your job, it's important that even if you don't think it's workers' comp related, don't do the legal analysis. Go ahead and report it to your employer. Make sure you do it immediately, get it in writing, and then file a Form 18.
A Form 18. Okay, so what you want to do, so if you do get hurt, you need to tell your employer first and foremost. A lot of people, I think, go, oh, I fell, but I feel fine. I'm sure it'll be okay.
That's right. And that can be a mistake, particularly whenever you have something in your shoulder or your back that's kind of latent. You don't see it, you don't feel it at first, and then it starts to progressively get worse. Then the employer starts questioning, well, did you really have an accident, or did something happen while you were at your house? And now you're telling me you had something happen a week ago. Not only that, there's a 30-day requirement for you to report it to your employer, and just make sure and get that in writing. Most employers have a formal process for that. They have somebody in HR or something like that for you to talk to and to get in the right track.
Yeah, just telling somebody, hey, this happened to me is not enough. You do need to have it in writing. All right, we're going to take a quick break. We're going to be right back with more of your text questions.